right, still with us to discuss, criminal defense attorney, former prosecutor Lindsay Richards. And Lindsay, let's talk about the style of the opening statements here. I thought they both did a great job. Let's start with the state. You know, one of the things you get taught in law school is that really opening statements is you're signposting, but you're really just telling a story. And I thought he told a fantastic story. It's really sort of hit the important elements, not the least of which is that this victim was compromised in many ways. She was sort of, I think, developmentally a little bit slow, and I think that plays into this, the relationships involved, and most importantly, the things that they did that point to this being a premeditated act.
I completely agree. I think the state did a very, very good job of painting a picture of this crime and how horrific it is and the victimization of this poor female. I think they did a great job. I think the defense did exactly what they were supposed to do as well. And as a criminal defense lawyer, I will say she did what she's supposed to as far as putting it back on the state. It is their burden. And as a defense attorney, you don't want to give your whole case away yet because you want to make sure the state delivers their case the way that they're supposed to. And so you want to wait and see how that plays out before really giving away your entire case. And she did a very good job of towing that line, of pointing out what might come up as inconsistent and wrong, but waiting to see how it all goes throughout the trial.
Yeah, I would have to agree with you. And I really highlighted something she said regarding the job of a defense attorney. Because, you know, we come under fire at times in court. There's no question about it. And she said, you know, I'm not here to sort of fight over this or whatever. I'm here to help you do your job. And I thought that was a nice way of stating it. You're sort of connecting with the jury, saying, look, I'm on your side, too. Look, I'm doing my job here. We have to get to the truth. And part of my job here is to help you find the truth.
I completely agree. And she did a really good job, too, of saying, look, we're not going to deny the things that are blatantly apparent, like the fact that he was there. That's obvious. They're going to be able to prove that. We're not going to sit here and make outrageous claims that he wasn't there. But what she said, which is a really good line, which is the presence is not participation. And I think if they keep coming back to that throughout their case, you know, there's a chance they, you know, could walk away with a not guilty. But they both did a very, very good job of setting up their case the way that they need to.
Now, let's talk about motive. So we mentioned that earlier. Now, we know prosecutors don't have to prove motive, but really the entire defense's case, you said they don't give it all away, but they gave a lot of it away. Where they're going is the fact that their client didn't have motive. It was really this other guy who had all the motive. He was in the relationship. He was the one that was picking the spots, et cetera, et cetera. This guy was just kind of along for the ride. At least that's the sense I got. So given the fact that prosecutors don't have to prove it, but they know that's where the defense is going, I would imagine they have to kind of address it, don't they?
It would be, they should. Now, it could be hard because there's really no real motive here that we've been privy to at this point in the trial. There's nothing that really points to Van Patten having any sort of motive, and a ton that points to the co-defendant.
But what about, let me cut in for a second. What about a thrill kill? What if it's just a thrill kill? Well, what if he just wants to please his friend, right? People do that all the time.
Correct. And that very could well be what the state, you know, tries to argue. I do think juries have a hard time with that, though, because it's hard to wrap your brain around just a vicious kill thrill, right? It's hard for people to imagine that someone has that level of depravity. And so I think jurors typically want to find a motive and some reason for behaving this way.
Yeah. And, you know, the way this went down, thrill kill might be the right words for it. All right, Lindsay Richards, thank you so much for joining me tonight. Truly appreciate it. We'll see you again real soon.